Good afternoon, everybody. I'm just going to give it a couple more minutes just in case anybody else joins, but I thought I would introduce myself. So my name is Olivia and I am a commercial and data protection solicitor here at Harrington Carmichael. You are joining this afternoon for our 11th WISE session, which is great. We run these, I think, on a monthly basis. So hopefully you'll find today's session useful, but please do look back and join us again if you can. A little overview about the firm. So Harrington Carmichael are a full service law firm based in Farnborough, Hampshire. We support businesses and also private individuals. And I have been here for 3 years now. So that's just a little overview about myself and the firm. But I think we can kick off with our first slide. So what is data protection? Well, we're going to delve into a very high level overview of what data protection is this afternoon. It may sound a bit dry, but it's crucial for any organisation that is handling personal data. So what is data protection? Well, simply put, it's about safeguarding individuals' personal information. And this could be anything from their names and addresses to more sensitive data like health records or financial details. Why is it important? Well, when things go wrong, and you may have hopefully not come across a data breach before, there can be some really serious consequences, including financial penalties, reputational damage, and legal action. So by understanding and adhering to the different data protection laws, hopefully we can mitigate that happening. And just to briefly touch on the key legislation that governs data protection, we've got, which you may have heard of before, UK GDPR, and also the Data Protection Act 2018, which sits alongside and kind of joins as two key pieces of legislation. They set out the responsibilities of the people that are processing data and also describe the rights of the data subjects whom are having their personal data processed. So just to touch on UK GDPR then, this is the primary data protection law legislation here in the UK. And I've just outlined some of the key principles that organisations must follow when processing personal data. So in no particular order, we've got lawfulness, fairness, and transparency. So that at a high level is looking at the valid reason for processing personal data and ensuring that when communicating to clients or customers or data subjects, the reason why you're doing so. So having that transparency and also informing people about how their data is being used within your organisation. One of the second ones we can look at is the purpose limitation. So under UK GDPR, data should only be collected for a specified, explicit and legitimate purposes. So often we will have clients who will conduct data audits and they will need to look at why they are processing that data and if they have a legitimate purpose to do so. Data minimization. Often I get asked, how long am I supposed to keep data on record for? And it really does depend on the type of data and I would say the industry in which your businesses fall into. So sometimes we have to keep data forever. Sometimes we have to keep data for a period of X amount of years for perhaps legal or regulatory or tax reasons. Other times we might need to keep data for as long as it's being processed and then it should be deleted afterwards. So the UK GDPR kind of sets that out. Personal data for accuracy again is just making sure that the data that we have on file is accurate, and just being transparent with what we have on record. Now, perhaps in your career or maybe even in your personal life, you've come across some personal data documents which include lots of legal jargon and specific terminology, and you think, oh my goodness, what does any of this mean? Well, fear not, that is not uncommon. What I thought I would do is just go through on a high level the main things that I tend to come across with my clients, and hopefully you'll have a bit of more of an understanding after our session's finished this afternoon. So typically speaking, you'll either be wearing one of two hats. The first one might be the data controller, the second one might be the data processor, and they're two very different roles. So the controller is the organisation that determines the purposes and means of processing the personal data. So they're in control. They are the ones who are telling the processor what to do with that data. And then the data processor is the person or organisation that processes it on behalf of the controller. Personal data, there's a very long definition under UK GDPR, but essentially it is information relating to an individual which can identify them. So as an overview again, it could be their names, their addresses, their email addresses, their telephone numbers, job titles, etc. And I know I touched on it briefly just now, but UK GDPR sets out different data subject rights. So you may have come across terminology like a DSAR, data subject access requests, etc. That is what that is one of the rights that data subjects have under UK GDPR. So for example, it's the right to access their data, their right to ask you to erase their data, or to restrict the processing. That's just a couple of examples there. Moving on, you may have heard of the ICO, and they are the Information Commissioner's Office, and that is the governing body for data protection here in the UK. So if a data subject wanted to report a breach or a complaint, they would go to this regulator. And also from a business perspective, if there is potentially a data breach, then they are the regulator which would deal with making that assessment and dealing with the kind of repercussions of the breach. We will touch on that shortly afterwards. Special categories of personal data. So this is a little bit different to ordinary categories, and this is because it's typically more sensitive data. So for example, you can have it would be information such as health data, biometric data, data about data subjects, religion or ethnicity or sexual orientation. There may need to be further considerations when processing this type of data. So we always advise clients to undertake an assessment of what data we have on record, and two, do we need to put in some more provisions to ensure that special category data is being processed, because it is slightly different in terms of the obligations on the processor and the things that we would need to put in place. And the last one is the criminal convictions and offences. So the ICO are very strict in imposing fines for data protection breaches. You may see, the big data breaches often are in the news. And again, we will touch on this a little bit later, but some ones that come to mind, there was one last year, I think, with BA and Boots. And I think the point here is that even though those big organisations are in the news, it can still affect small businesses. So it's really important to ensure that we have the right compliance with data protection laws, and also the right documents, and also knowing how to deal with a suspected data breach should that hopefully not happen. So we understand now the terminology. We know we need to make an assessment as to whether we are processing ordinary personal data, special category data. We've touched on what a controller or a processor is. Now, what documents do we need to put in place? So you may have come across, I mean, I'm sure everybody listening will have come across a privacy notice at one point or another. But as an overview, this is a clear and concise document that informs individuals how their personal data is collected, used, shared, and protected. And typically speaking, this would be a document that would sit on your website, often alongside a cookies policy as well. And that you can also have internal privacy policies too. But typically speaking, we would have an external privacy policy or notice, the interchangeable words, to show to data subjects what data we're collecting through our website and also through our business relationship as well. A data protection policy, so that is a policy which outlines your organisation's data protection procedures and responsibilities. It's important to have one of these in place because it shows compliance with UK GDPR. And often we find if the regulator asks questions following a breach, for example, it's good to have a really clear policy in place to show we have these documents and we're showing compliance. And following on from that point, then we've got a data protection, a data breach management plan. So this would be a detailed plan for responding to and managing data breaches, including incident reporting. So where do staff go if they think that there's been a data breach? Do we have a place on our intranet that we've got some documents? Do we know who we need to report it to? Do you have a DPO at your organisation? If not, who is the person responsible? So that plan would hopefully assist people should a data breach occur. And then also it would outline investigation, what we would need to do, and the notification procedures. Often people forget that if there is a data breach, they firstly run to potentially notifying the ICO, but actually what we need to think about is, do we need to tell the affected data subjects as well? So that plan will encapsulate that, and it's really handy. Again, it's all hopefully to mitigate the risk, but should that happen, at least you've got something in place where you aren't scrambling and you know exactly what to do. Depending also on the size of your business, you may want to think about putting in place some other documents. So I've just got a few examples here. So records of processing activities report, and that is a document that categorizes the personal data, the purposes for processing, the categories of data subjects, recipients of data, and data transfer details. Whenever you are transferring data to someone, to let's say a new supplier, for example, often we would advise for you to complete a data protection impact assessment. So that's a DPIA. And they can be found as a template, which is on the ICO's website, which is really helpful. So I'm happy to share that after this session, should you want to have a read. And essentially, that is just looking at potential risks to data subjects, and also assessing it against the legislation and ensuring that the individual's rights and freedoms from your processing is protected. I know I'm speaking probably quite high level here, but should you have kind of any questions about that point, I'd be happy to discuss. As well, you may have come across a document called a data processing agreement. So that, again, is a contractual agreement between the controller and the processor, and that's to put in place and really set out clearly what obligations the parties have. I didn't mention it earlier, but depending on the role, if you are the controller or the processor, will determine what obligations you have under both a contract but also under legislation. So typically speaking, contracts are slightly more onerous on the processor because the risk of a breach occurring is typically going to come from a processor in a contractual relationship as opposed to a controller. And obviously the controller is the one that's telling them how to process it. So they want to have they want to have restrictions around what to do when processing that data. Another consideration that I've put down here in my notes is a further consideration should be given if you are processing data outside of the UK. Now, I know in this WISE session, I'm just kind of giving a very high level overview of data protection, but I wanted to just flag that as a thought, because often this point can be overlooked, but there may be data transfer considerations that you would need to have because dependent on where that data is going to or from depends on the level of protections that you would need to have in place. Again, it's something that I'd be happy to discuss outside of this session, but just something for you to have a think about. Do I process any data outside of the UK? Where is that data being processed? And what do I need to have in place to ensure that the processing is compliant with data protection laws here in the UK? So, as discussed, hopefully you would never have to come across dealing with a data breach, but I thought that it would be useful for me to just outline some steps that I would recommend should that happen. Data breaches can be really stressful for organisations to deal with, and so I just wanted to kind of go over a few points. The first is identifying if there actually has been a data breach by seeking legal advice. So sometimes in the past, I've had clients come to me and say, oh my goodness, Olivia, there's been a data breach. What do we do? I'm stressing out. It's, do we need to notify the ICO? What do we do? So my recommendation would be to speak to your legal advisors or speak to somebody, a data protection expert who will be able to conduct an analysis at the beginning to assess, has there actually been a breach or not? If there has been a breach, then we'd need to contain that. So identifying the extent of the breach and taking immediate steps to prevent further data loss. So that would be working with your IT team to ensure that perhaps a corrupted file or corrupted system that has been compromised is shut down, as an example. The third thing would be to assess the impact and the risk. You may have heard this before, but sometimes when data breaches happen, it's not uncommon for the perpetrator to try and breach and to get into the systems again, because they know that the security at the time has been compromised, for example, or is not as strong as maybe beforehand. So assessing the risk, is there going to be another breach? And determining the potential consequences of the breach and looking at the sensitivity of the compromised data. So you may find that the personal data that has been compromised might be names, telephone numbers, addresses of a data subject. Another time you might find that it's names, addresses, health data, political opinions, etc. So you would need to identify what has been compromised, and then we would look into the consequences of the sensitivity of the data that's been breached. Now, After that's been completed, we would also need to do an assessment as to whether or not we would need to notify the ICO. So typically speaking, they have a 72-hour deadline to report. So we might find that, okay, there has been a data breach. This is the data that's been compromised. We're going to make an evaluation. We look at how much it affects the individuals and how many, that there's many factors to the assessment, and do we need to report to the ICO? The fifth one would be to communicate with the affected individuals. So as explained, out of the analysis, we may need to tell the affected data subjects, hey, I'm really sorry to say there's been a data breach and your personal data has been compromised. The fifth recommendation would be to identify and investigate the cause for the data breach. So conducting thorough investigations to identify the root cause of the breach and implementing measures to prevent similar incidences in the future. And I think that ties in nicely with point 6. So having a look at what cybersecurity processes you have in place. Have staff recently been given data protection training? Those kind of things, are our policies and procedures up to scratch, and have they been reviewed recently? They can all be really great remedial actions that you can take, hopefully beforehand to prevent a data breach, but afterwards as well. One thing I will note is that often data protection laws change. Typically in law, our legislation doesn't really change. But with data protection, it is constantly changing. So you might have some policies in place at the moment that might be out of date. A lot of people, there was a big boom in 2018 when the UK left the EU and we formed our own UK GDPR. The law has changed since 2018, so there may be some things that need tweaking in your policies to make sure that you are compliant with the current UK legislation position. And the last one is to learn from the incident. So again, yeah, I've spoken myself. So updating policies and procedures, making sure that we are compliant, we know what to do, we have that plan in place, and learning from it. Now, just to touch on, as I said, the ICO are strict when it comes to non-compliance to data protection. And I don't want to use this to scare you, but just to give you an overview, financial penalties can be really quite serious. The ICO can impose significant fines for breaches of data protection law, with a maximum amount of being the highest of 17.5 million or 4% of the undertaking's total worldwide turnover. Now, hopefully that would never happen, but they have the capability of doing that. So I think that's a really important point to know. And they do often fine organisations for not complying with data protection laws. One thing that is important as well is reputational damage. A lot of people forget this, but actually, if you have a data breach that occurs and your clients have to find out because they've been part of it, and it comes to light, it can have a really bad impact on a company's reputation, and it, like I've mentioned, it erodes the trust of your clients moving forward. Legal action is another one. So sometimes we find if there's been a data breach, individuals may be looking for compensation for their data being compromised, and they may take legal action because of the breach. And operational disruption. So if there has been a breach, for example, and your systems need to be shut down, think about how much time and money you're potentially losing if you have to then mitigate and have everyone have a day off work, for example, because you've got to then have a massive overview of your cybersecurity, for example. So I think out of this training session this morning, I hope that you can kind of have a bit of an overview of data protection, what laws are in place. And I guess my final comment would be that by understanding and adhering to the data protection laws, organisations can protect themselves from risks and build trust with their customers and employees. What I will do is stick around for a few moments after our session today. If you've got any questions, please feel free to share those in the chat box. My email address is below, so olivia.larkin@hc.law, and my telephone number's there. If you have any questions that you want to run past me, please feel free to get in touch. I'd love to hear from you. But otherwise, I hope that you have enjoyed today's WISE session. Make sure that you look out for our next one. I believe that's going to be in the new year. And I hope everyone has a fantastic Christmas break. So, as I said, I'll stick around for a little bit should anyone have any questions. But otherwise, thank you for joining. Really appreciate it.